The next matter to come before us this morning is State of Ohio versus Delrico Thomas. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, if you'd like to reserve any type of rebuttal, I'm keeping the clock this morning and we'll try to keep you apprised with the passage of time. Court's read the briefs and are ready to proceed when you are.
Good morning, Your Honors. I am Richard Kudici. I am court-appointed counsel for Delrico Thomas this morning. It was a few months ago that I was in California. Becky and I were there. We had just left San Francisco, and we were in Big Sur. I was at Grappado State Park, just getting out of the brisk Pacific Ocean. We were chatting about a case in San Francisco where was a very brutal murder, and I was listening to a defense lawyer who was saying, this is all going to come out. My client was just driving a car and just picking up his relative who was the alleged shooter. And I thought about Delrico, and I thought about this case, and I turned to Becky and I said, what's it going to take? I wonder if this guy's going to get a separate trial. And I said, what will it be to get a separate trial? And Becky replied to me, well, it depends what's fair. And you know, that's what this case is greatly about. Your Honors, what convicted Delrico Thomas? Now, if you listen to the state here, it was circumstantial evidence that was put together well. What circumstantial evidence? Was it really being the cousin of the alleged shooter, of the killer? What would it take to get a separate trial in this case? Do you think that having the medical examiner, bullets in the head, pictures, a burnt car, you think those things were prejudicial maybe to the average juror? You know, the first thing the state says in their brief is, the medical examiner said, bullets, killing. Do you think in this case there was some guilt by association? Shouldn't the case have been severed, Your Honors? And that's realistically what we're here to talk about today. There was insufficient evidence to take this matter to the jury. Now in this instance, Grayson is alleged to have driven by rallies on Waterloo Road, shot the victim, took off, and then he makes certain phone calls claimingly to my client, Delrico Thomas. But what is the evidence about the reason for those calls? And I ask you to scrutinize that, because what was said was that Grayson was taking this tan Buick, the famous tan Buick, back to the place where he was going to return it to his friend, who was the owner, so to speak, of the car. And he needed a ride home. The neighbor, Paul, said he saw the two of them in the vehicle. What was seen? So when we talk about two things, severance, or we talk about manifest weight of the evidence, when we're talking about a tampering charge, what was seen? We saw two people cleaning up a car. So the question becomes, if you look at the testimony of Paul, he says, well, he wasn't sure what was going on, but he thinks he saw some cleaning going on. If you listen to Star Casey, who had driven in the car, she said the car was trashy, just like kids would typically do in a car. She said there was nothing suspicious at all about the behavior she saw. So Delrico now is charged with tampering. Well, who else is charged with tampering? Grayson. Who has a reason to tamper? Well, perhaps the alleged killer. Why? What evidence, ladies, Your Honors, does my client have? What evidence is there that my client knew that Grayson was an alleged killer? Now, if I were to kill somebody, I am not necessarily going to say to Becky, hey, will you help me clean out this car because I just shot somebody? Now, I would ask her to clean out the car, which I always have to ask her to clean out the car, by the way. I'm not going to say to her, make a confession. Why would I? There is no evidence to suggest that Delrico was involved with any information. Now, this car later is found, and it's Kelly says she sees the car burning on September 27th. So the murder happens on the 18th. Now we're at the 27th. And this car evidence of being burned all of a sudden is involved as evidence in this trial. Is that going to be evidence at Delrico's trial? No. My client's in no way even implicated with that. He's certainly not charged with it. So if we look at the scene, the evidence, the record demonstrates that the detective said that the video shows my client lob something over the fence. Now all of a sudden, from lobbing something over the fence, we jump to the conclusion that he's tampering with evidence. There's no evidence as to what was lobbed. There's no evidence as to what the evidence was that was tampered with. There is no evidence as to what was in the car. In fact, the police officer says, well, usually if there's a shooting, there's going to be some shells in the car. That's the evidence. Now we're going to jump to the conclusion that, well, the car is the evidence too. So we're tampering now with the car, supposedly. So we're tampering what's in the car, we're tampering with the car. Well, notwithstanding, there is no evidence that my client had any information whatsoever. It's legitimate to believe that he was cleaning out the car at the request of Grayson without Grayson having any communication to him about a murder. And it's certainly legitimate to believe that there were no shells in the car. Why? Because no shells were found. The detective went and took a look with a metal detector. The other thing is now my client gets charged with obstructing of justice because he gives a statement and he's talking about not being at the scene, even though the police officer knows about it. Your Honor, it was a clear abuse of discretion to not sever this case. If you have the co-defendant, Grayson, with murder, weapon under disability, you have him with the tampering, all these things put together, a prejudicial portrait painted by the state. Oh, well, that didn't just happen by mistake or by error. Certainly the strategy of the government in this case was to try Delrico with Grayson. Is this fair? No, Your Honors, it is not fair. The jury is considering a very serious killing next to Delrico. Next to Delrico is Grayson tampering with, if it is to believe that he committed the murder, clearly Grayson knew he was tampering because he knew about the event. There's nothing to demonstrate that Delrico was. But after all, the state says he was trying to hinder an investigation. What proof is there to that? So if you put that notion together, the manifest weight argument, with the notion of prejudicial joinder, you have unfairness. You bring in other acts. Here all of a sudden we're bringing other acts of Grayson's tampering with evidence. Is that fair? I think one of the things that is critical to believe for the jury is that there was strong evidence that he was cleaning out the car because he knew. But if you put the two together, that's where the severance prejudice comes into be, because now we have guilt by association. We have blood is thicker than water by the cousins Delrico and Grayson. And you really need to scrutinize, Your Honors, what evidence is there? The evidence, that is, from Grayson himself was he dropped the car off, he was calling to get a ride home. And the misleading character and the prejudicial nature of this communication, this joinder, is very clear when you put it all together again with the pictures, the medical examiner, and the burning vehicle. The jury just couldn't weigh this evidence sufficiently without losing their way. And that is the violation of a manifest weight. That is the argument as to a manifest weight here, Your Honors. The state's strategic painting of this matter from the start by joinder the inability for the state to really prove that my client had any knowledge about the investigation. After all, it was 15, 20 minutes earlier that the crime actually was alleged to have been committed. So this circumstantial evidence by the state is insufficient. Now, let me conclude my initial argument here with two other things, particularly the obstructing of justice charge. Your Honors, I'm here to tell you, now I'm a defense lawyer, you can lie to the police. It's not a nice thing to do. I wouldn't recommend it, by the way. But you can lie to the police. In this instance, what the state of Ohio had to prove is my client lied to the police with a purpose, with his purpose to hinder the investigation. Now, when my client's making this statement, it's nearly 2 months after the event. It is at least a month, or it's several weeks after Grayshawn gets put in custody. My client knew Grayshawn was in custody. He knew that he was charged with a murder by the state's own admission in their brief. So was my client lying when the police knew that he was there by the video? The police knew that Grayshawn had been arrested and that he was charged. The police knew that they were trying to manipulate the interview of Delrico to get a confession. What hindrance occurred? So the government, the police, the state of Ohio is going to say the hindrance was they were hindering, Delrico was hindering the investigation of Grayshawn. They already knew about Grayshawn. My client didn't say anything about Grayshawn. All he said was, I wasn't there. The police already knew that. There was absolutely no hindrance whatsoever. Now, finally to say, let's talk about consecutive sentences for a minute. I disagree fully with Mr. Kasey. There still is a fact finding. This court has a unique opportunity today to make a better definition of what is required with a fact finding. You can't just recite the magic words. In all due respect, the lower court didn't talk about the history of my client. There was no PSI involved in this case. There was only a fact finding language. the court has considered this. There needs to be some foundation, some substance to the notion of what in fact is the result for the finding of consecutive sentences. So if there are any questions, I'd be glad to entertain them at this time.
About 3 minutes remaining for rebuttal, since you wish to preserve it.
Thank you, Your Honor.
May it please the court, Richard Kasey representing the state of Ohio in this case. Consecutive sentences. Mr. Kudichieff suggests that this court has an opportunity, or a unique opportunity, to flesh out the law in this area. The Supreme Court of Ohio has already done that. January of 2014, July of 2014, the Ohio Supreme Court in State v. Bunnell issued a decision on the proposition that the trial court must expressly make the findings for consecutive sentences and give the reasons supporting those findings at the time of sentencing. Mr. Kudichieff wants this court to say, yes, that proposition is right. Well, it isn't, because the Supreme Court said in July of 2014 that the trial court is not required to give reasons when it makes the findings to impose consecutive sentences. July of 2014, but now it's March of 2015, and this issue is still being argued. The former statute, this court knows this as well as anyone, the former statute prior to Foster required findings and reasons to impose consecutive sentences. HB 86 only reinstated or revived, as they call it, the findings component. Reasons are not required. If the sentencing court makes those consecutive sentence findings verbatim, that is all the court has to do. Now, the court can substantially comply with the consecutive sentence statute. That would be an occasion for an appellate court to look at the language to make sure that the trial court considered and in effect made those findings. But the appellate court is not looking for a justification. If you're looking for a justification, you're looking for reasons. The Supreme Court has said in language that should be comprehensible to anybody that no reasons are required. So that issue is not on the table. Now, rhetorically, why would Delrico Thomas lie, completely, totally lie about his activities on the morning of September 18th? He said, did not see Grayshaw. I was never in that rendezvous. When I left 2nd Street, I left by myself. He lied. That's the basis of the obstruction charge. It was his intent. He doesn't have to be successful. This is not Einstein. You've heard Einstein quoted here. This man is not Einstein. But it was his purpose, the jury could find, it was his intent to hinder the prosecution of Grayshawn Thomas. It does not matter that the police told him, we know you were there. He persists in his lies. That's the offense. To hinder the prosecution investigation of Grayshawn Thomas, it's a clear-cut case. The evidence is sufficient on that charge. It certainly isn't against the manifest weight of the evidence. The tampering charge. We've heard about this. Delrico is not charged with the homicide. He's just charged with tampering and the obstruction. Tampering is altering the interior or modifying the interior of that rendezvous, knowing that an official investigation has been or will be instituted. That requires some knowledge, and I will concede that, knowledge on Delrico's part that of the official investigation can only be the shooting of Alfonso Golden in broad daylight on a public street. That is going to cause an official investigation. So he had to have some knowledge of that. His knowledge for sufficiency purposes is again the motive. His cousin Woodall, Dad, the victim, Golden, fear of his life and concerned about Delrico. And Delrico and Grayshawn are cousins. We're not saying that just because or blood may be thicker than water that they have to be guilty, but the circumstantial evidence again is, and for sufficiency purposes, is enough to show that Grayshawn is the shooter, Delrico knew about it, Grayshawn calls him, help me, got to clean out this car.
Even for sufficiency purposes, the courts, you're not persuading us to engage in some sort of inference stacking, correct?
No.
Appears we might be getting kind of near that line of inference stacking.
As long as we don't go past it, I'm happy. I don't think we're piling inference on inference. It's not stacking an inference that Grayshawn indicated to Delrico that he shot the guy and he needs help. That's not stacking that inference on any other inference. That stands alone, in my view. But if there's a particular concern that I can address, I'll attempt to do that.
Well, the statement that there was not, that the inference that I just committed a crime and I need help. The next activity that happens is some activity with respect to the car. And the purpose for that activity, there's no testimony about why we're cleaning out the car.
No, there's no testimony in the state's case as to why they were cleaning it out. But they were cleaning out the car because they both knew that that car was at the murder scene. Now, I haven't looked at stacking inference on inference in a while, so I'm a little flat-footed here. But the inference, I don't believe the inference of why they were cleaning out the car has to be, well, I'm not answering your question very well because I haven't thought about it.
Perhaps it wasn't well phrased as a question. Nevertheless,
No, the topic is, the question is a proper one, but I am not able to articulate a very good answer at the moment. Although I don't think there was any claim that the stacking inference on inference on inference was violated here. That's the best I can do right now.
could you address for a moment the severing of trial?
Sure. Where the evidence, okay, the joinder is permissible when the defendants are charged with the same offense. They're both charged with tampering. Or where they are engaged in a course of conduct, which I think you have right here also. And where the evidence, even if there's a severance, where the evidence in the separate trial is still going to be admissible in the severed trial, then the court in its discretion need not sever the charges. Now, from the state's view, just about everything that would come in against Grayshon would have come in a separate trial against Delrico. It's got to.
The circumstantial in both cases.
Yes. Why is Delrico lying? How does he commit obstruction of justice? Who cares? Why should anybody care if he lies about his activities with Grayshon Thomas? Well, we only care because of the circumstantial evidence that Grayshon is the shooter. Why do we care that Delrico was cleaning out that rendezvous at around 9 a.m. on September 18th? Well, because of the circumstantial evidence that that is the car that was driven during the shooting. So that's got to come in. So there's absolutely no abuse of discretion as to the court not granting a severance. That says nothing about the quality or the sufficiency or anything else of that evidence, but as far as severance is concerned, that's got to come in. So the state doesn't believe that the severance issue has any weight at all. I don't know how much time I have left, but...
Just about 3.5 minutes, Mr. Smith.
Okay, I'll be happy to answer any further questions. If not...
Seeing none. Thank you. Council, we have just under 3 minutes remaining for vote.
Under 3
Are we on the
minutes?
same clock, Mr. Pucci?
Well, I have an Apple, I have an iPhone, so. Yes, Your Honor. You know, I agree, you know, the Supreme Court has spoken, okay, maybe you don't need a reason. Come on, you need to make a finding. We can't just find that the sky is green. The finding has to be some basis for that. You can't, it's unfair, it's not right to just use certain language. And I also disagree with one thing the state said. There was testimony as to why that car was being cleaned out. Starr herself said clearly the car was trashy. That's the number one thing we know. And also we know that the car was being returned to its owner, whom. There is testimony about reasoning for cleaning out that car. Now, relative to prejudicial issues, Your Honor, let me ask you one thing, because Mr. Casay says, well, we're going to have all these things. We're going to have the medical examiner. We're going to have the pictures of the murder. We're going to have this and that. Well, we're not going to have Grace Sean's testimony. Oh, well, Grace Sean testified. Maybe not the best testifier either. That testified in Delrico's trial, that all goes to prejudice. And then the burning car, let's not just gloss over that. Somehow the burning car gets in there. That seems pretty significant to me. But you know what the state says? The state says over and over, the jury could have found. Well, they did find. That's what we're here for today. The jury did find because they lost their way for several reasons, as I've indicated. More particularly the prejudicial joinder. There's insufficient evidence to get this case to the jury. A motion for acquittal should have been granted. More particularly, the manifest weight of the evidence demonstrates clearly that there is insufficiency to support this verdict of guilty beyond a reasonable doubt. The jury lost its way when you put together Grace Sean and Delrico with the tampering. Scrutinize that, Your Honors. I ask you to do so. Everything would not come in Delrico's case that came into this. And that's how the state was able to craft this matter in a sufficient fashion. What evidence of tampering is there? The only thing would be the bullets, the shell casing. There's no claim of burning in the tampering, you heard that said. The jury can find he lied, I'll give you that, but they can't find under this evidence, and that's what you must look at. He did not lie to hide Grace Sean, he lied to incriminate, so he wouldn't incriminate himself. Your Honors, I leave you with a question. What is fair? And in this instance, what happened here with a joint trial was not fair. There was a manifest miscarriage of justice, and you must reverse this case and send it back for a separate trial.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.
Thank you, Your Honors, for your time and consideration.